can you, Michal, perhaps put it on a slideshow, and if I kindly ask you, you can turn off the slide. You can turn the slides on as we will speak.
Sure.
Okay. Thank you.
They're on the slides.
All right. So perhaps I'll start. Good afternoon to everybody. Hope you will enjoy 1 hour together with Stano and myself. As Michal said, this is a somewhat unique partnership. Law firms are not very much inclined to partner, especially if they're competitors. But since Stano and I, we really do like each other a lot, we agreed and made relevant efforts so that also other people that are relevant agreed. And we will do the presentation together for you. So next slide, please. I think the next slide is just our contact details. So if you need anything or if you would like to ask something which we will not be able to respond, because I'm sure there will be questions we will not be able to respond online, feel free to email them to us, and we will take care of them. Next slide, please. So the next slide is really what we will be talking about. We have, when thinking about how to use the time most efficiently, we have somewhat most frequently asked questions in terms of 3 areas. One is the labor code, one is the health and safety, and one is the social security and other measures that are adopted in order to promote employment. If you have any other, feel free to ask, use the chat as Michal suggested. And the next slide, please, which directs us to one of the most frequently asked questions that I have, and that is related to the home office and whether employees can or actually do they have to work from home if the employer so wishes. It used to be different. The response used to be different, but now I think as of April 4th, we have a good response for you in this respect. The employer can indeed order the home office to the employees. It is in these difficult times, if the type of the agreed work so permits. Before this amendment to the labor code was adopted, home office was always subject to the agreement. Only in exceptional circumstances it could have been somewhat imposed, but very, very, very rarely. Now the employers can do so if the agreed type of work so permits. What would that mean? That would mean that if presence at the workplace is no longer possible, if the presence at the workplace is not inevitable, and if there are relevant tools, or if the employer so wishes, the employees can stay at home. This is a right of the employer to ask the employees to work from home, and there is a corresponding duty of the employees to observe that. So if once there is an order to work from home, the employees actually have to work from home unless they have other obstacles on their part. For example, they're on a sick leave or on a quarantine leave or on a pandemic leave, whatever that may be. The employees can also ask for home office, again, if the work so permits and there are no serious operational reasons if they bring the home office. Well, there are 2 conditions always. The agreed work so permits. What would that be? Of course, if somebody who is servicing a machinery or operates a device which is located at the employer's workplace, home office would not be possible. With administrative employees, home office usually is possible. There are certain circumstances where it is problematic. As far as I have seen, and we have discussed it also with Stano, there might be some hurdles even to administrative workers. For example, call centers might have difficulties to work from home because of the phone calls being recorded, because of GDPR, because of the confidentiality and confidential data being transmitted. Those might be difficulties when it comes to ordering the home office that the employer has to tackle. If the technical infrastructure so allows, even there the home office is possible, and I know that some banks also are able to service the call centers from home. There have been numerous articles about the home office published, and there are always 3 issues that the employers usually ask when it comes to home office. And first is, how am I going to monitor that the employees actually work? Yeah, first of all, you have measuring tools. There are various options, and if there are no other work, like daily timesheets work. Picking up the phone and check also works. If you are implementing monitoring tools, which means that you're going to monitor the employer system, make sure that this is notified to the employees, because this would meet the criteria for employee monitoring. And if this differs from what you have already had, please make sure that this is properly covered and the employees are notified how you monitor them. Of course, this cannot be intrusive. You cannot just simply enable cameras and just watch the employee as he or she works the entire day. But any changes to what you already have in terms of monitoring and how the people work and when they work, please make sure that those are notified and not extra intrusive. Then there is another huge issue which has been discussed on numerous forums for long, and it has not been somewhat altered, and that is health and safety. I will share via email, or I will share with AmCham. There is actually a very nice guide published by the National Labor Inspectorate when it comes to health and safety in home offices, because this is still a duty that vests with the employer. Are we having troubles with hearing?
No.
Hello?
We can hear you well, Katka. Go on.
Can hear you well.
Yeah, because I'm receiving messages. I'm receiving messages that some people might not hear me. Michal, can you hear me? All right. The vast majority of people are saying that they can hear me.
Yes, Katka, we can hear you.
Okay, then I guess the problem is not on my side if a lot of people can really hear me. All right, so health and safety. So there is a guide published by the National Labor Inspectorate which says which rules have to be observed. I can share the article. It's really interesting, but I would point to certain measures that are suggested, and those especially relate to people that have administrative work and work with computers. And actually, the National Labor Inspectorate is saying that laptop is not something which is designed for work for the whole day. If you are providing employees with a laptop, they should have separate keyboards, they should have mouse, and they should also have monitors. Because the touchpads or any other, and the laptop keyboards do not meet the criteria defined by the Special Decree on Health and Safety at Work. Another interesting feature is that you have to make sure that there is a pop-up screen on the employer system, which will promote the employees to take a break after every 4 hours, and that means that you will take care of actually mandatory breaks or breaks at work, so that the employees do not sit. They should also be equipped with proper chairs and everything, so that this is something which you can hardly control in these difficult times, but at least you have to consult or somehow deal with it with the employees and ask them whether they have all the comfort that you need or they need for their work. Another thing is also the compensation and the rules that you have to make sure that they're applicable, and that people properly record overtime, that they also are online when you expect them to do. This is all something which usually is covered one quite robust, but one single document, which says what are the rules for the homework, how people work from home, what are the monitoring tools, how they are compensated, and this is something what you always should have in place when you have a lot of employees working from home. And I will pass on to Stano. This was all what I wanted to cover when it comes to home office. Stano?
Can you hear me?
Yeah, I can hear you now, yes. You can do the next slide, please, Michal.
Okay, so good afternoon, everybody. Under the special conditions which are making us not only parents but also teachers for our kids, you will recall that if you move to another slide, that with respect to childcare allowances, there was different legal impact in the normal circumstances, while in these circumstances the Slovak government and the Slovak parliament introduced a new legislation which relates only to this temporary period of time, hopefully temporary. It's basically based on the principle that due to the situation that all kindergartens and all schools are closed, the parents who are taking care of their kids and staying at home, they are allowed to allowances equaling to 55% of what we call daily assessment base. And as already said before, this is going to last for the whole period of time until these preventive measures are taken. From the legislative point of view, it's quite unique because the government did not dig into various parts of the labor code and other codes, but it introduced, especially with respect to labor code, it introduced a special part, which is part 11, and it summarizes basically the whole measures related directly to the labor code, which we will talk about later on. So this is from my side. Katka, go ahead.
Yeah, thank you. Thank you for keeping on this slide. What I wanted to say is that you will always see a little like an aim on various slides. When you see that, I have always put it in a place where it is visible, but unless you're not totally bored, you can keep searching for it because in some slides it will be hidden. That means that the measure that is adopted is always temporary. It's always related to COVID crisis and will not apply when this is over. You will see it on some slides it will be not because some rules are not changed. Next slide, Michal, please. Can you move the next slide? I will just pass on the message, Michal, to move the slide.
Yes. We can move one more.
One more?
Okay, that's fine.
Yeah. So as Stanislav said, there are certain measures that the employees taking. One back, please. There are certain measures that are adopted with respect to employees taking care for their children. That is so-called pandemic sick leave. And many people were asking whether they can work while they're on the pandemic sick leave taking care of their children. Yes, they can, but if they're paid, the rule is that there is no dual payment. Either you get the Social Security benefit or you get the salary, but you cannot be both. In this respect, I would like to maybe emphasize a very nice initiative that I have seen on the LinkedIn. It was shared by, or it's an initiative driven by Profesia and many other and other companies. And they are actually asking and proposing to the government kind of a joint situation in which you can get the Social Security payment and work at the same time. This initiative was supported by over 200 employers employing over 60,000 employees, and they're all claiming that this will tremendously help in the situation because people can distribute the time between the work and between taking care of the children. And on the other hand, of course, the working time will be shortened. They will agree also on the salary decrease and the the salary exposure by the employers will be cut to 50%. So if you're interested and you are on LinkedIn, you can see it. I can share. I will also reshare it. It was posted by the CEO of Profesia, and it is a very interesting initiative. So if you're interested and you don't know about it and want to join, please do so. Stanley. Over to you, Stano.
Okay, so the next one is about basically the holidays, because normally the holidays are scheduled ahead, and under the given circumstances, what the government is trying to say is to be more flexible in with respect to holidays, and it divided the entitlements and also the time periods for ordering the holidays for 7 days if it's a holiday for this particular year. And when we're talking about what we call old holidays, which is from the previous years, then the notice of the employer could be given 2 days ahead. Of course, with the consent of the employees, these periods can be shortened. What I would like to point out in this respect is that this obviously does not relate to mass holidays. When the employer is ordering mass holidays for significant part of its operations, and this is pretty clear that it only relates to like what we call management of the normal holidays, but it does not relate to the mass holidays according to section 111.3 of the Labor Code. Yeah, if we move to another one, this is again a very typical question these days, also from foreign employers or companies which have subsidiaries in Slovakia, and that relates to reduction of the salary. Basically, the original legal environment was based on the condition that if you have trade union representative and if you agreed with them serious operational situations, then of course you can cut the holidays for 60% of their average earnings. What the government introduced at the moment is the new measure, and it relates also to those employers which don't have a trade union representative. In such a case, those employers may basically reduce the compensation to 80% of their average earnings. Minimum is the minimum wage, of course, which cannot go below that. And this is again a temporary measure. Today, the big employers, basically from automotive sector, announced and discussed with the Slovak government other proposals, but I will get back to that at the end of the webinar. At least those, I will try to summarize those 7 points which they basically proposed to the Slovak government. So at the moment, if you have trade unions representative 60%, if you don't have, you go to 80%, but you cannot go below the minimum wage. Yeah, we can move 1, 2 slides. One more, please. Okay.
Yeah, I will just perhaps add to that what Dana was mentioning. The decision of providing the salary compensation of 8% needs to be somewhat adopted and in a proper manner, which means it needs to be a management decision, just like when you do the redundancies. It is not something which comes out of the blue. Employers need to properly decide on that and properly draft a solution saying that we have serious operational reasons which does not allow us to assign work to this and this categories of employees because it may not relate to everybody, and then you can cut down the salaries. And of course, it needs to be properly announced, and the employees need to know, and it of course needs to be prospective, not retrospective. Anytime we see that some changes would like to be seen retrospectively, but that is usually not possible, and in employment law that is almost never possible. We also have been asked many questions about, we know that we cannot cut down the salaries, but can we cut bonuses or can we reduce bonuses? Well, responses depends. What you have agreed, that means that you need to carefully review what kind of bonus structures you have. In principle, if you have agreed something in the employment agreement or collective agreement or in any other agreement with the employer representative, you have to look what the wording is. And what you are searching for is whether there is an entitlement or not. So if you have something in the employment agreement which says that the employee will get bonus subject to certain KPIs, that cannot be changed unilaterally. That can be only changed from same would apply if you have something like that in the collective agreement or any other agreement with the employee representative. What usually is the situation is that there is a link in the employment agreement to some internal regulation which says that there are bonuses. And again, what you search is the keyword entitlement or discretionary bonus. If the employer retains the right to provide bonus and it's not a duty, which means there is no entitlement on the other side, then you can change it. Of course, again, the change needs to be prospective, not retrospective. So if there are bonuses that are performance related for the past year and you have no discretion, you have to pay those out. Another third thing that you need to look into is the criteria. Usually the bonuses are discretionary and are also subject to the employer's performance. So if the employer is not performing well, then the employer can cut down or defer or not provide bonuses. If this is the case, you're fine, then you don't have to repay those. But if this is not the case, and even in the internal regulation, you have a clear entitlement and very clear criteria which are driven by the employee only, that might be difficult. So please remember, if you are about to reduce bonuses, you really need to look how they are regulated and where they are regulated. The same question, next slide please, Michal. The same question relates to benefits. Many employers are now trying to foresee some crisis scenarios, are planning what's going to be ahead, and are trying to reduce bonuses. The benefits are, various kinds. It can be cars, it can be phones, it can be sport cards, it can be extra meal vouchers, whatever that is. Again, the same principle would apply for benefits. You need to look how the particular benefit is regulated. So if there is a clear entitlement to have a company car and the employee is allowed to use it also for personal purposes, I don't see a reason why this how can this be changed unilaterally. It's not possible, especially if you have it regulated in the employment agreement. Some benefit may be also agreed in the collective agreement. Again, that is subject to the employee representative's consent in terms of changing or cutting it out. Again, what you will be looking for is, again, the entitlement. Entitlements to the cars, entitlements to the phones are usually very vastly present. So if you want to change that, you need to have a look how it is regulated. If in the employment agreement that requires the consent of the employees. If this is the internal regulation that is providing for these benefits or any other benefits, then you need to look whether there is an entitlement or not. Usually, even if there is an entitlement, and clearly the devices or any other benefits are provided for work-related purposes, phone, cars, and computers, and the employees do not work, of course, there is no need to have the benefit in place. If this is not the case, again, benefits will stay. There are usually other benefits like, sport cards, extra meal vouchers, or whatever that may be, that can be unilaterally changed if unilaterally regulated. And again, the change must be prospective, not take back what has already been provided. And Last but not least, next slide, please. What I would like to navigate you to is the possibility to share employees. Again, we have seen already in this respect many success stories. So some employers have employees that they cannot use because they have no work for them, and the others are in huge demand. And we have seen the Tesco being, taking over the employees from various employers in hotel industry, gastronomy, or taxi drivers that are now helping on a temporary basis to deliver the groceries. We have seen Pantare employees that have been assigned to Lidl in order to help again the food distribution. If you are overstaffed and there is any way and any chance that you can think of borrowing your employees, I would really encourage you to do so. It's not very difficult. It's something that we already know. This is not a temporary measure that is newly adopted. It's been envisaged and people have been creative using it now. Employee sharing is something that is really, really, really now important because it will keep our labor market a little bit more stable in these difficult times. I must say that there are certain rules that apply to temporary assignments. You need to have proper contract structure in place, but this is not a rocket science, and we actually in A&O are developing a very good sample so that you will be able to use if you're interested. And so if you have a sharing situation and you think you may be able to borrow your employees or borrow from someone else, feel free to get back to us. There are two types of agreements that you need to have in place that are between the home and host employer and then between the employees. And there are, of course, certain rules which needs to be observed, and but those are fairly obvious and have been here for so long that I think everybody knows them. I will just, maybe briefly summarize the most important ones, and those are that once you're borrowing your employees to someone else, that person will be, of course, assigning the work, or that company or employer will be assigning the work, will be managing the employee, and will also be, that employee will need to have the same conditions as the core staff of that employer. That is crucial. You will be still keep on paying the employees, which means that the home employer is paying and is receiving the money from the host employer. There is a time constraint. It's a temporary measure. The maximum is 24 months that you can agree. Of course, this is way enough for now. But more important criteria is that you can only prolong it 4 times. So if you start doing it on a monthly basis, it's only 4 times and full period. So it needs to be also carefully considered how you time it. But as I said, this is something which is vastly used now. So if you have a workforce that you can share, I would really encourage everyone to do so. It's a good measure, and it is a good time to use it now. Stanley, over to you.
Yes, so again, this is a very typical question we are getting these days from the employers. Basically, before the government introduced what they call first aid measures or first aid kit, there were no rules, so some of the employers, they had in their minds already like worst case scenarios. Nevertheless, the government and the parliament did not touch upon the individual redundancies as well as mass dismissal process. So for those who are already or went through the mass dismissal process, they understand that it's a quite specific process. It's long-lasting, and especially if you have trade unions representative, it might be a battle between you and them. So this will take time, and the time periods were not shortened or due to the current situation. So the same applies also to the individual redundancies, which means that the concurrence of the salary during the termination period and the severance payment is still there, so there is nothing new. We just wanted to point this out because it's obvious that some of the employers are already thinking about redundancies, either individual or even like in the form of mass dismissal. So there are no changes in this respect, and you have to follow all the time periods and provide entitlements for the employees. Another one relates to measure which is again temporary, and if we move to another slide, Michal, please. Yes, thank you. This again, the original situation before the crisis was that the shifts basically were managed on a weekly basis, week ahead, for a week. Now, because the government wants to give more flexibility to the employers, they changed this rule, and they said that in the current situation it could be 2-day notification ahead, but it's also valid, or it lasts for 1 week. So this has something to do only with the management of the shifts. It has nothing to do with the working time reduced. So these cannot be unilaterally reduced, but the shifts, if you have working shifts in your operations, the shifts can be managed on basically 2 days basis or 2 days ahead, and they last then for a week. Katka? Yeah.
I would maybe just add a few points that relate to staff reduction. What I have seen is that the first thing that the employers actually look into are the fixed-term contracts, and when they actually expire, those usually are not renewed when they're uncertain times. And also the employees in probation periods are also a group of employees that can be dismissed with immediate effect almost. So if you really are in need of cutting the workforce, these two groups are, and maybe it's not going to sound nice, but are the usual suspects. And of course, if you have, in factories, you see that, there are contracts with the agencies that provide the workers being reviewed and terms changed depending on what the production will be and what the forecast is. Next slide, please, Michal. There is a very interesting question that I see from Guido Andrea. I will get to that at the end of the presentation because it's a very question now, especially if we have a unilateral possibility to alter the compensation or to change the compensation to 80%. I will surely respond to that, and I will be very, very, very curious what Stano will also say, and we might have different view on that. So we'll get back to that at the end of the presentation. So with respect to health and safety, there are many questions, but by far there is one that sits on top of the bulk of questions, and that is, do I have to provide face masks and hand sanitizers or gloves, or what do I have to provide? Well, the response depends. There are certain professions that need to be equipped with face masks and the gloves, and they need to wash their hands. Those are determined in the governmental measure of 18th March, and those groups are usually drivers that are providing, that are delivering cargo or whatever they are delivering, pilots, funeral companies that even have to have respirators, ambulance drivers, and so these are the companies that need to be provided with the face mask and the hand sanitizer. In terms of the others, there is really, really no clear guidance, but every employer under the health and safety regulation needs to have certain preventive measures in place. So if you are if you have a workplace where a lot of employees are actually gathering, temperature measuring, face masks, and tools to wash the hands are something which almost everybody is providing. There's no clear duty, of course, if you have no chance to get the face mask. You can also navigate the employees to their duty, because under the governmental decrees they also have to wear face masks when going outside. It's also their responsibility to take care of their health. So of course, if you're totally unable to do that, that would be, I guess, understandable. But actually, even the labor inspector is encouraging the employers to take good care of their employees and provide all the necessary measures to cover the face and the upper breathing apparatus, and to wash the hands and keep the working spaces clean. Of course, if there is a chance to reduce the amount of people that are located in the same room, for example, offices that are for more than one person, like they're sitting 3 people together, you can adapt their schedule, their working schedule, if of course possible. But again, there is no clear guidance, and there is just common sense rules. In terms of the home office, I have already touched what the rules are, especially when it comes to working with the computers and prompting employees to take breaks and recently there has been amendment to the health and safety regulation. In principle, suspend certain time periods. I would emphasize, next slide please, Michal. I would really, really, really emphasize that the time periods suspended employers are not relieved from the notification duties triggered by onboarding, change of the workplace, introduction of new technology or tools. This is just postponed. This means that if the employers are unable to provide to meet the notification duty, meaning to notify the employee what the health and safety regulation is, and they need to do it, on a certain regular basis, or if there are changes, then only you don't have to do it now, but you will have to do it the first thing possible, which means if you are unable to do it throughout the whole crisis, then 1 month following the end of COVID crisis and the end of emergency status. The reasoning report to the change of the health and safety regulations is also indicating and prompting employers to use online tools in order to meet the notification criteria, or audio technique where the employers will be able to search through the presentation, or respond to a very basic test and then click send, and they will be confirming that they have been notified about the health and safety regulation. Of course, in many employers this is not possible, because this is done by gathering the people in a meeting room and in person. Again, in such a case, you will need to provide it 1 day, which means not later than 1 month following the end of the emergency status. And then another certain time periods are suspended. I will not go through the entire catalog, but because that usually relates to certain certified technicians, which need to go through the testing and regular examinations, which need to be done over a regular time period. If the license permit is going to expire throughout the crisis, it will be deemed to be 1 month following the end, and then the person can be re-qualified. Also, the reconditioning stays, they need to be the time periods for those, because those are mandatory for the 3rd and 4th category of workers doing work. That time period is also suspended, and again, not non-existing. There is still a duty. You will need to fulfill it later when the crisis is. And over to you, Stanley.
Yeah. So we are already in the last part, which relates to the social security measures, or the measures which the government passed in this area. It's not only social security; it's also health insurance and others, retirement insurance, But basically the first one is, and the first change relates to the fact that, which I already talked about, it's the 80% of the gross salary or gross wage, but not less than the minimum salary. And this is also kept by 200,000 euros per employer per 1 month. So initially the government wanted these measures only to those employees who were from the law closed because of the current situation. Fortunately, in the wording as it was passed by the Parliament, it is extended. So it does not only apply to those employers who had to shut down their businesses because of the current situation, but also to those who are, let's say, significantly impacted. And but of course, in such a case, the entitlement will be decreased. So now most of the employers, but not most of the companies, are very interested in the application of the words significantly impacted. I think, and we will provide you with some guidance at the end of this presentation. Katka will tell you more about the methodology and how these levels of compensations are structured, and also how the decrease of the turnover is basically calculated and what periods need to be compared. There are basically 3 different methodologies for that. So, but again, as said, further aid by the Slovak government is under discussion, and maybe this will change after the government basically discusses the changes proposed today by the big employers. Because, for instance, with respect to employers like Volkswagen and OMEs from automotive sector, 200,000 euros per month per employer is basically not too much, and I think it's also kept by 800,000 per one employer totally for the crisis period. So this was not. They were not able to use this opportunity, and that's why they very openly discussed and proposed to the government measures which they announced today. So another social, if we move to the next slide, another social benefit or the measure taken in the field of social security is already the sick leave or the compensation for the parents taking care for the kids. I said that it's up to 55% of the daily assessment base. It's for the whole duration of this extraordinary situation, and the Social Security Office is accepting also like these confirmations by email or via phone. So it's not a big deal behind this, and of course it's a temporary measure because there are caps on this as well, and maybe some parents could not leave with 55% of their daily assessment base. It's also capped. So, but this is for now, and let's hope that this situation will not last forever. And if yes, then the government will have to pass something different. One important, if you move to the next slide, one important measure which was introduced last week is the possibility to postpone the Social Security contributions, but also health insurance contributions and all the contributions the employers are paying. So this can be postponed until the 31st of July this year, and the government at the same time has the possibility to postpone this period. So it relates to the situation when the revenues of the employers are down up to 40%, for more than 40%, comparing to the previous year. And in such case, the Social Security contributions, health insurance contributions, and other contributions which are paid by the employers could be postponed, and the employees can pay them later on, or the Social Security office, health insurance companies may agree with them on some kind of a schedule for payment of those contributions. So this is again interesting measure which was taken. This also relates to the additional or to the third pillar of the Social Security system. And one more measure which was taken relates to the unemployment benefits. So if we move another slide, the payment of unemployment benefits that would cease during the crisis or the extraordinary situation are extended by 1 month, and the government may even extend this period further. So these are basically the measures adopted in the field of Social Security health insurance system, and Katka will now explain to you the 80%, how it works, and what is the cap and the calculation.
Well, how it works, we don't know yet, at least as far as I know, because the state aid, or the compensation of the salaries, is something which has not been adopted yet, at least not yet to my knowledge. Stanley, please correct me if I'm wrong. We've been trying to track down the document that was actually proposed and discussed at government, but we were unable to do that yesterday, apparently because of the changes that it's going to undergo. But at least the old document that was a kind of a framework for the court in terms of salary compensation said the following: there will be 2 types of salary compensations provided to first group, those who have to close or suspend operation, leave employees home, and who do not implement dismissals 2 months. And those will be able to apply for 80% of the employee's average earning, maximum 1,100 per employee. And again, this subject to cap, which is 200,000 euros a month and 800,000 total for the whole duration of the project. This is going to be financed from the EU funds or from the state budget. We will see. The exact rules are not yet adopted. We only know that this is going to be provided by the local labor authorities, and there will be also the applications will be submitted there. But still, we are waiting for the final document. This is not final. This is what is being proposed. And again, as Stan was saying, it's probably going to be discussed and maybe altered. And so the first group is for those who had to close or suspend operation, and the other group is for those who did not have to close or suspend operation. There was not such a duty imposed by the government in the various measures ordering the closure of various operations. And those who did not implement dismissals but experienced decrease in revenue, and the next slide, please, those will be able also to apply for compensation depending on the volume of the decrease in the revenues. Again, the calculation, how we're going to calculate the decrease in revenues, will be provided. There is no clear guidance yet, just like there is no clear guidance for the calculating of the 40% decrease in order to get your Social Security payment delayed. So the decrease is quantified from 20 to 80%, and you see the amount of compensation and the total caps apply. We have shared the links. You may have a look. There were either summaries or the documents published where you can look for the compensation. One important question or one important note to this is we've been asked whether you can apply for both. You can apply for the salary contribution or the contribution to cover salaries, and you can also at the same time ask for suspension or for delay of your Social Security and health insurance payments. The response is yes. Another question that we have been asked many times is whether these measures, the salary compensation and also the Social Security and health insurance payment postponements apply to only certain categories of employers. We have not seen any restrictions in the law so far, in the adopted regulations so far. Although when it comes to salaries, measures were initially aimed at small and medium-sized enterprises. Document that is defining the rules, how the aid should work, is not containing any restrictions of the employer. One important and one last important note in this, there will be numerous sworn declarations that the employers will have to submit when applying for the salary compensation contribution. And one of those is the confirmation that the employees were paid 80% of the average salary when they had to stay home. So those who are actually on 60% will need to be increased to 80%, and only then you can get the salary compensation benefit or the contribution. So you have to make yourself a calculation what it is, what it makes financially, and what it is, the financial impact, whether this is going to help or not. And I guess maybe this was also one of the reasons why this is not in a final shape yet, and employers are still vastly commenting and indicating whether this is going to help or not. This is it. I will, Dana, if you look, there is a question. There, it is possible.
I will just, before we start to answer questions, I will just summarize those 7 proposals which the big employers proposed today, because I have it here in front of me. So if someone is interested, the first one is basically that they want the states to acquire a higher stake in compensation of the labor costs for the employees in the metric 60-20-20 in percentage. So 60 paid by the government, 20 paid by the employer, and 20 paid for the employee. The other one is they want to postpone the effectiveness of the Act on Bankruptcy and Restructuring. So they want to have a stop on a final stage of enforcement of the judgment, the execution. They want to the restructuring to prevail over the bankruptcy proceeding. The fifth proposal is relates to the utilities calculation and the payment, because originally they ordered more higher volumes than due to the crisis at the moment, because they are not producing. They cannot basically pay because they cannot even consume it. So they want to the utilities such as gas and electricity to be paid on a real value or real level taken over. The sixth proposal is to increase the loan resources of Exim Banka, Slovenský investičný holdings, and others in the form of state guarantee. And the very last one is they are proposing responsibility of the Ministry of Economy to grant individual state aid. So as the government said short before this webinar, they are now discussing it, and this or the very next week they will pass decisions on these particular measures. But as I could see at least from the reaction of the Ministry of Economy, I think the majority of this could be accepted by the government, and I'm also bearing in mind that those which relate to the stop of executions and act on bankruptcy and restructuring, these are already basically prepared by the Ministry of Justice. So this is basically already done. So, okay. So that's about it from my side. And
we can go to questions.
Yes.
I see three, so I'll go from top down. So the first question is whether there can be 60% salary compensation agreed in the individual contract with the employees.
Okay.
Response to that from my side is yes. If you contractually agree on individual basis with the employees, yes, you can have 60%. However, there is one provision in the labor code which is saying that you can deviate from the provisions of the labor code only to the benefit of the employee. So those who are very strict interpreters of the labor code may say you cannot deviate, but my opinion is you can. Then Lior?
Yeah, you're right.
It's not
I was
agree. I think I'm right, but it was just whether you agree or whether you are strict interpreter.
Yeah.
Okay, then there is a question about NGOs, civic associations, and foundations and their non-profit status, and that's why whether there are any measures in this respect.
Yeah,
not that I'm aware of.
Yeah. This is again. Of course, the NGOs are not making profit, and they're basically not typical entrepreneurs, but they are at the same time employers. So they are affected somehow by this crisis. The situation is again in the application of the newly proposed legislation. I think it's more accounting issue it's accounting issue than the legal issue, because when we looked into this problem, we realized that the act directly refers to act on accounting. So if the accountants would somehow justify that the decrease is acceptable, then I think again also the state authorities could be somehow willing to accept such application. But it's really something which needs to be tested and pretty soon. Yeah.
Then there is threshold percentages for revenues decreased for March. Might be. I was operating with the version that I could locate and I could track down on the government web page. It is no longer there, so I can hardly confirm whether that's 10, 20, 30, or 40%, or whether that's different. So again, this is not yet in a final shape, and may well be that it's down.
Yeah. And the proposals of the big employers, they are publicly available. They were presented during the briefing or conference after the discussion with the government and all the related ministries. I can forward you. Well, it's basically, I think it should be also in the form of memorandum, but they presented it openly, and they even mentioned. I have it in my remarks, so I can send it to you, Pavel, if you want.
Or we can share whatever we have. We can share to Michal, and Michal can pass it on then to the participants so that everybody is on the same page and well informed.
Okay.
Any other questions?
I think you have the contacts to all of us, so if you have individual questions, just feel free to email us. You have at the very beginning of the presentation You have our contact details for those who don't know us. I think most of you do. We're ready to answer any questions you might have.
Okay, hello, over to you.
Yeah? Michal? Yeah?
Michal, can you hear us? Right.
Yes, Katka, there's one more question for you.
Yes, I have responded. I will do share, Gabriela. Yes.
Okay, fine.
Perfect. Thank you very much then, Stano and Katka. Can you hear me now?
Yep.
Perfect.
Yes.
Thank you very much once again for your presentation. What we have done in the past is we have published the presentation on our website after the webinar, so it can be available to other AmCham members that have not been able to participate at the meeting. So we'll try to do our best to share with our members as well. And just a few remarks to our fellow AmCham members. We're preparing further webinars after the Easter holidays. So please check our website for further updates. We are planning to present more webinars on useful topics from different areas that can be useful to your business operations. Having said that, I would like to thank once again Katarína Matulníková of Overy and Stanislav Ďurica of Squire, Patton, Boggs, and wish everybody healthy Easter holidays.
Okay,
yeah.
Thank you.
Have a good rest of the day, everybody.
Yep. Thank you.
Bye-bye.
Bye.